Bismillahirrahmanirrahim. Alhamdulillahi Rabbil Alameen. Wassalatu wassalam ala Sayyidina Muhammad wa ala alihi wa ashabihi ajma'in. Assalamu alaikum, brothers, sisters, friends, viewers. May peace be upon you. This is Edward Ahmed Mitchell, the Deputy Director of the Council on American Islamic Relations, welcoming you to today's episode of CAIR on Air. Thank you so much for joining us. A special thank you to our listeners on American Muslim 360. We're always happy to be working with you on this program. Today, inshallah, we're going to be discussing the Supreme Court nomination of Ketanji Jackson. The hearing has been held this week. It's wrapping up today. As you all have seen, there were 2 days of questioning that just finished yesterday, and all sorts of important things were discussed, all sorts of non-important things were discussed. There was all sorts of foolishness, as you expect in a Supreme Court hearing these days. But there was a lot of substance, and there are some issues that are going to be very relevant to the Muslim community that we want to highlight today. Relevant not only to our community, but the broader country, everyone who cares about civil rights and human rights and justice here and abroad. The Supreme Court can impact all of those things, and we got some indication of how Judge Jackson might impact those things if she becomes Justice Jackson. So with that, I want to bring on our Government Affairs Director, Robert S. McCaw, to discuss this important topic with me. Let's bring on Robert.
Assalamu alaikum to you and our audience.
Wa alaikum assalam wa rahmatullahi wa barakatuh, Robert. Thank you so much for joining us. How are you doing today?
Alhamdulillah, it's a good day.
It's a good day. Alhamdulillah, good. So, Robert, we're going to make this a bit more of a conversation. So since you and I have some thoughts to share about all the interesting things that happened during this hearing, we're just going to have a chat, inshallah, about it, and also welcome any thoughts from our viewers and listeners. So first, let's highlight, Robert, where we are in terms of the hearing. Most people know now how this process works. They've seen Kavanaugh's hearing, they've seen Gorsuch's hearing, they've seen Justice Barrett's hearing. So people are now, the average American is familiar with this process. But for those who still may not be, can you just give us a rundown of how the process works and where the process stands right now?
Sure. So recently, Supreme Court Justice Stephen Breyer announced he plans to retire. He's currently sitting on the Supreme Court. It's not vacant. And the Biden administration nominated Judge Jackson as the individual which they wish to fill his seat. Judge Jackson serves on the U.S. Court of Appeals. She has a long judicial career. She's the right fit for the court. So now this nomination goes to the Senate Judiciary Committee, where the Democrats control the committee, but it's almost evenly split among members, both Democrat, Republican. They are going through the nomination hearing process. It started on Monday. Like you said, it ends today. These were 4 days of open hearings. The first day was more opening statements. Tuesday, Wednesday were the real grilling of Judge Jackson. Today, they have a panel of witnesses that, know Jackson, have worked with her. They're being grilled to get more insights on her judicial career. And then it's been reported that around April 4th, the chair of the committee, Dick Durbin, is going to hold a committee meeting where they will then vote on Judge Jackson on whether their committee is recommending her nomination proceed to the Senate floor where the larger Senate can vote. Now, it's already been said that while Republicans have voiced opposition, it doesn't seem that they're going to oppose her nomination. The committee, if it was split, it could still go to the Senate floor. If no Democrat breaks, they only need 51 votes, and they have the 50 votes plus the 51st being the President Pro Tem of the Senate, Kamala Harris, the Vice President of the United States, so she can be the tiebreaker if needed. But I would like to note that for her nomination, because she serves on the U.S. Court of Appeals for the D.C. Circuit, a few Republicans voted for her then, and so it's assumed that they wouldn't turn face on her now, and that she should, hopefully, she will rise, become the first African-American judge to sit on the Supreme Court. She would also be the first judge that was a public defender. And I think that adds a critical and key insight to the court, which is missing.
Yeah, I mean, the whole thing here is perspective, right? The experiences you've had legally and professionally and personally impact how you think and how you look at cases, how you view certain facts. I mean, Judging cases is not a mathematical quantitative thing where every judge is going to reach the same conclusion. That's not how the human mind works. And so if you have judges who have diverse professional experiences, it can change and maybe even enhance the way those debates and discussions happen behind the scenes and get to an outcome that is more in line with ideally the Constitution and even more ideally justice. And so I think, we at CAIR, when her nomination was announced, even though we do not endorse nominees, we did certainly welcome the fact that this would be a historic appointment, the first African-American woman to serve in the Supreme Court. That matters. And also her professional, more importantly, her professional background, that she was a public defender, that she had defended Guantanamo Bay inmates, that she had been in private practice, she'd been a trial judge, and also a Court of Appeals judge. Those are all unique professional experiences that you don't find among many of the other members of the court all in one person. So there is some hope that could certainly diversify the perspective behind Supreme Court decisions. Now, Robert, those things were discussed, her background, but there were also some interesting topics discussed. So it seems there were three hot button issues that came up. One was Guantanamo Bay. Another was her rulings related to child sex pornography, child pornography. And then the other issue that you noted, Robert, you can mention the other issue you wanted to talk about.
So it was a very interesting hearing. As you said, there were some theatrics from the Republican side. I would say that there were also some Republican arguments where they were bringing up the past two Republican nominations of judges, kind of rehashing those arguments and airing grievances. So there was some theatrics at play. We can kind of narrow in on Guantanamo and speak to the broader issues.
Yeah. So let's start with Guantanamo. So, I mean, it seemed that the argument they were making was that, number one, that the fact that she represented Guantanamo inmates is a problem. And in the past, people have usually recognized that if you're a lawyer representing a client, that does not necessarily reflect anything about you. You're doing your job. And especially if you're a public defender who is meant to represent anyone and everyone who comes, you're just doing your job. You make sure that everyone has the right to counsel and a fair trial and a fair shake in court. And that's what she did. And for Guantanamo Bay inmates in particular, who were incredibly vulnerable insofar as many of these men were arrested, thrown in prison in Guantanamo, tortured for years, never charged with a crime, many of them not even guilty of doing anything at all, later turned out to be completely innocent of even the allegations that were made against them. And so she defended some of these people to fight for their legal rights to receive proper due process in court. But some people weren't happy about that. In particular, Lindsey Graham, through what I can only describe as a hissy fit over Judge Jackson's representation of Guantanamo inmates. And some of them were all senators were upset that she filed a briefing in which she noted factually that the Bush administration had committed war crimes. And they were just upset. How dare you call President Bush and Vice President Cheney war criminals? Well, they committed war crimes. Torture is a war crime. Killing innocent people is a war crime. Kidnapping people and renditioning them and then putting them in boxes, hanging them upside down, beating them, that is the very definition of torture, which is a war crime according to the Geneva Convention. So she didn't call them war criminals, but if the shoe fits. Let's play briefly a clip of Lindsey Graham, if we have it, and some of his performance, we could say, during the hearing. Let's play that.
Let's watch that.
They all die in jail if they're going to go back and kill Americans. It won't bother me one bit if 39 of them die in prison. That's a better outcome than letting them go.
So that was a partial clip, not the full thing. But the key thing he was saying there is that he believes that these men, some of them, that if they were to go to trial, there's not enough evidence to convict them. But he still considers them dangerous, and therefore they have to be kept in prison, and he doesn't mind if they die in prison. Well, that's a completely circular argument. You're saying you don't have enough evidence to prove they committed a crime. Yet at the same time, you are declaring they are dangerous and pose a threat, and therefore they must be locked in prison. That is exactly the kind of circular logic that we do not allow. If you want to put someone in prison and detain them there, provide evidence of a crime they have committed, not a crime you think they might commit in the future. This isn't pre-crime. This is a minority report.
True.
What did they do in the past that justifies putting them in prison? You then take that evidence before a trial, whether it's a military court, a civilian court, whatever, but you take that before a fair judge and you get a verdict. That is how the system is supposed to work.
That's how the Constitution works.
That's how it works. And yet that is not what Mr. Graham would like to see happen. Now, Judge Jackson responded to that quite eloquently. She noted that, number one, when you represent someone, that does not mean you agree with whatever they allegedly did. It doesn't mean that you support whatever their cause is. It means you're standing up for their constitutional right to due process. That's an elementary idea that Senator Graham is quite aware of. But again, this is politics. But the other thing, though, that I noticed, Robert, and some of you noticed as well, is that usually when Democrats in particular get challenged on issues like Guantanamo Bay, they're still somewhat afraid to just come out and say the truth. For example, one of the senators I noticed tried to make the argument, well, we should close Guantanamo because it costs a lot of money to keep it open. We're having to spend millions of dollars a year to keep it open. So it's kind of appealing to the pocketbook of your average American. But that's not the problem. The problem is that they have not been charged with crimes, and therefore they should either be charged or released. And there's nothing wrong with standing up for that principle. But your thoughts. So, Robert, let me ask you this. This is important to know. Where does the Guantanamo Bay prison stand right now in terms of the status of people still there? What's going on with the prison right now?
Sure.
And what have we in the Muslim community been demanding be done with the remaining inmates in the prison?
Okay, so let's break it all down. Since Guantanamo Bay was open around 2001, there have been about 780 detainees cycled through the prison. And currently there are about 38 detainees still in the prison being held without charge, without trial. There have been periodic reviews of their cases, but there has never been a trial. Some of these people have been charged or would be charged for the acts of 9/11. A number of these individuals had nothing to do with 9/11 and were picked up in Afghanistan or other hotspots and are just awaiting to be tried, waiting for the trial. A number of these people have actually been tortured by the U.S. government, and a number of reasons why the government doesn't want to bring these to trial is because there's a very sound argument that any evidence brought forward by torture is inadmissible and is unconstitutional. In fact, Judge Brown, when she was working in private practice, at one point with the Morrison and Foster law firm, she was representing 20 retired federal judges that were trying to make that case that reliance on evidence extracted through torture is unconstitutional. So the Biden administration would like to shut the prison down. I was actually just on 2 separate calls about Guantanamo today with our allies, other civil rights and nonprofit groups. They're currently looking at trying to transfer 2 more prisoners out of the prison to other third-party countries. So they're slowly decreasing those number of prisoners. But these are people that, regardless of what you say, they deserve to be charged. They deserve to know what the charges are, and they deserve an attorney, and they deserve a trial, and a fair trial. And this is something that Lindsey Graham and other Republicans don't want to concede. And, there was actually 2 lines of arguments from Republicans. Some thought that, okay, as Brown was a public defender, she was assigned 4 detainees over a course of 3 years. It was that after she went into private practice, she filed Friends of the Brief amicus briefs to ongoing Guantanamo detainee periodic reviews or trials because, she had been involved. She knows the amount of lack of due process that there is, and she had her own arguments that she wanted to continue to make as a private citizen. Now, Republicans have been saying she was overzealous for daring to provide any legal arguments in these cases as a private citizen. Like an attorney cannot, comment on past clients or, any private citizen, unless they are against these detainees, they should not have a right to, comment in these cases. And so, yes, there was a lot of theatrics. We continue to see reluctance from a number of Democrats about the prison. And again, you're right. They always talk about how much the prison is. No one wants to talk about the rights that these prisoners are enjoined by the U.S. Constitution. And really, there's a justice for Americans and there's a justice for detainees by everyone having their day in court with fair legal representation and an unbiased trial.
Yeah. So where do we go from here? So they're going to have a vote in the committee. If that is a split vote, it could still move forward to the Senate floor. And then if all the Democrats vote in favor, Kamala Harris votes in favor, 51, that's it. And she is confirmed to replace Justice Breyer. On the other hand, it's possible she could get some Republican support. It seemed like Senator Ben Sasse was very much engaging her on the substantive issues, her views on due process, substantive due process. And so it seemed like that might be a possibility for a positive vote, and others may as well. As you noted, Republicans, several of them voted for her the last time she went before the Senate for hearing. So we'll see what happens. Now,
it's hopeful right now. The outlook is more hopeful. Not a sure thing, but hopeful.
Yeah. So let me ask you this. So then thinking ahead to if she is confirmed, I'm thinking about, what impact does someone with her professional background have on some of the cases that are relevant to the Muslim community? It stands to reason that someone who has defended Guantanamo inmates, someone who has argued for the importance of due process applying to everyone in American custody, would be likely, if a case like that comes before the Supreme Court, to recognize those same principles when they're formulating a decision about how to handle not only Guantanamo Bay inmates, but anyone who's being detained or otherwise targeted by the government. So I'm wondering if her presence there could have some impact on everything from watch list litigation to a search and seizure, which is an evolving area of law. Right now, we've got ongoing lawsuits about CBP's practice of taking cell phones from Muslim travelers, in particular at the airport when they're coming into the country. I wonder if her presence there will provide a unique perspective on some of those issues. What are your thoughts?
Yeah, I think not only her experience as a public defender, but as a judge in trial, having actually gone through real cases involving real people and seeing their lived experiences and having to render verdicts on them, we've seen that she does not just follow sentencing guidelines to the T like a machine, like you said, but she tries to look at all the factors on how the law was written and what's being mandated and what room she has as an individual justice to apply her own good decision making. And she seems like someone that she said she did not prescribe to a single legal theory, and she was criticized by some people for that. But for me, that means she's flexible in her approaches, and I think would look at all these cases, especially these cases involving the civil rights of other impacted minority communities, whether that's Muslims or immigrants or others, more practically and less dogmatically. And, I would think she'd be more inclined to rule just not on party lines, but actually on her belief of what the law says and what is just for the individual in that trial. And so I would be hopeful that it would be nice to have less ideologues and more, realist on the court.
Yeah, one of the things that I think people on the left and the right often do is they confuse what they want to happen for what the Constitution requires to happen. In theory, the Constitution doesn't care about your political beliefs, whether it's about Guantanamo or abortion or gun control or anything else. The Constitution is what it is. But most people don't think of it that way. They think the constitutional result should be what they want to happen, what they think is the right thing to happen. And sadly, the Constitution is written by human beings, and interpreting that, you can get it wrong sometimes. And even interpreting correctly, you might get to an outcome that you might consider unjust. That is the system that we have. So I think we're always striving to try to make sure that we can get as close to an outcome that is both just and obviously constitutional when we are arguing cases in courts of law. Robert, thank you so much for joining us today to discuss this issue. I'm sure we'll all be watching what happens next very closely to see how the Supreme Court proceeds and also see what rulings might come out of the court in the coming year that are important not only to our community but the country at large. Thank you, Robert. Assalamu alaikum.
Thank you. Wa alaikum assalam.
Today for today's episode of CAIR on Air. We look forward to seeing you next week, inshallah. May Allah grant all of you the ability to reach Ramadan safely and grant us all a successful Ramadan. Ameen. Wassalatu wassalamu ala Sayyidina Muhammad wa ala alihi wa sahbihi ajma'in. Alhamdulillah. Assalamu alaikum, everyone. Peace be upon you.